Hold on. What sense does that make? Why in the blue blazes would you do that?
I am, Judge, that's.
Blue blazes is a legal term.
But if I may speak, at the time, a lot of the residents, there was a transition of systems, so that's why I opened up the portal. It wasn't that we went in and maliciously blocked the portal. There's a transfer of a new system we're going to, and a lot of people just, they got locked out. So we had to reopen the portal for people, but it wasn't anything that we deliberately did. But it does get locked out if you have an NSF or insufficient funds or in the middle of legal. That's when the accounting department, the corporate will lock it out. But hers, I don't show, was locked out.
I was locked out because you opened it. I sat in your office and you opened it while you were sitting there.
But that's what I'm saying, it wasn't locked.
But it wasn't locked. I just wanted to make sure, ma'am, I was just trying to figure out why were you locked out? I'm going to order that the defendant is to post $5,606.50 into court escrow. He's to do that by the 18th of August. That's 7 days from today's date. I would remind you that it needs to be cash to be posted into court escrow. If not posted, then the judgment, the default entered will stand in the redemption period. And I would allow, to the extent it would be necessary, plaintiff to amend their complaint so that the parties are properly reflected if that becomes an issue. But it shouldn't be an issue. So if it's not posted, the judgment stands. If it is posted, then I'm going to extend the redemption period so that it expires. It will expire on September 11th. I'm not doing it that day. I'm going to make it September 14th. Questions regarding that?
Thank you for your time.
Thank you, Your Honor. Have a great day, guys.
Oh, one last question. Is the court issuing an order? Are you expecting us to come up with one? It's probably worth asking.
No, by the time you guys try to do an order, you're going to be arguing about the order.
Thank you.
So
The court issue.
So yeah, you can do an order, right?
All right.
Okay, good.
Thank you, Judge.
Do it.
Have a wonderful day.
Have a good
All right.
one.
Yeah. Jesus, I don't know. So I wrote it in the file. So we'll take the rest. What? Did you find out the answer?
I did.
Okay. Showcase. Haverhill on Clark versus Woods.
Good morning, Your Honor. I died before the plaintiff and my clients.
Good morning, Your Honor. Tish Lee on behalf of Ms. Woods, and I believe Ms. Smith has an identical motion up. Are you planning to hear?
Why you gracing us with your presence?
Oh, because I miss you, Your Honor.
Is that what it is?
Yeah, I just it's been so long, and
Yes.
you know, YouTube is not the same as seeing you in person.
Yeah, I have to go places just to show people that I exist outside of YouTube. All right. So I will also call the case of Haverhill on Clark versus.
Thank you, Your Honor. And both Ms. Woods and Ms. Smith are present. Well,
Okay.
Yeah.
All right. Go ahead.
so Your Honor, this is our motion for summary disposition based on the short notice under the CARES Act. I know that the two of us have gone back and forth about this for a long, long time, Your Honor. You know my arguments and my position, but if you want me to spell them out, I can. But for the record, we did file our motion for summary disposition based on the fact that the demand for possession in both of these cases was only 7 days. And we believe the CARES Act requires that those notices, and because the notices were inadequate, that both of these matters should be dismissed for lack of jurisdiction under the Park Forest doctrine, Park Forest of Blackman versus Smith. And so we filed that motion, and in response, plaintiff has argued that the CARES Act was essentially repealed by a HUD notice of interim final rule. And in our response, we argue essentially three things, three things: that the interim final rule was essentially revoked by HUD 2 weeks later, that it doesn't apply to the plaintiff's property because plaintiff's property is a low-income housing tax credit property governed by IRS Treasury rules and not HUD. And third, that essentially constitutionally, you cannot repeal an act of Congress via administrative action by HUD.
Okay. I'm not even going to deal with that last one. It's
All right.
the world, but I get what you're saying, but
All right.
okay. All right. Silence.
Yes. Your Honor, as the court knows that both of these cases were filed as non-payment of rent cases. Essentially, the argument is a due process notice issue. Notice is the purpose of notice is to well inform the defendant or the other party of the claims and allegations against them, so that they can properly defend themselves or they can be afforded an opportunity to be heard in court. And we're now months in of these two cases. Multiple hearings have been had. Dispositive motions have been filed, responses. Defendants have availed themselves of the court's jurisdiction to the right to counsel. And the CARES Act essentially, respectfully, Judge, is a tactic. It's just a tactic. It's a stall tactic. It's used to delay the inevitable. This argument is not based on the merits of these cases. Not one conversation has been had regarding the merits of the cases. What is the defendant? Are the defendants able to pay? Are they seeking resources? Are they challenging the arrears? I don't know this because I haven't had any conversation regarding the merits of the case. Is this effective counsel or the effective use of this court's resources? I do not believe so, Your Honor, because at the end of the day, it is still to brush this under the rug, to dismiss it would be contrary to judicial economy and what's in the best interest of both parties. It would be detrimental to the defendant. It would also be prejudicial to my client to delay this any further. We are here. Defendants have just recently asked me for, sister counsel just recently asked me for ledgers. So now we're getting on the merits of the case. So instead of understanding what the status is regarding the arrears, we're now still fighting over this due process issue, this CARES Act issue. And I mean, tenants have subsidies for a reason. They have it. I believe that they need it. And it is essential to preserve these subsidies, like tech properties, Your Honor. And part of effective counsel is to help them preserve these relationships and these subsidies. And
Also, when we were here the last time, if you recall, one of the things I said is that you may want to file a new notice.
we did do that, Your Honor.
Okay.
So I mean, I think both are.
When does that? If it's a 30-day, when is that set to expire?
Actually, I believe it's already expired. And so instead of my take on this, Judge, is even if a case was dismissed, it's still.
You're going to refile immediately with a new notice.
Say that again?
If these cases are dismissed, you're going to refile with a new notice.
Right, but my issue here, Your Honor, is it would be detrimental to the defendant. If preservation of these subsidies or these properties or this tenancy is crucial. Multiple filings, even if it results in a dismissal, still works against them. It shows that a case was filed against them in summary proceedings. Yes, it was dismissed, but then another case was filed. Instead of utilizing this time to maybe
but how does
by way of a CD?
How does that? Okay. I'm not sure how that is detrimental necessarily to?
Well, because they could potentially risk losing their tenancy status. And sometimes, this is lifetime property. If it's lifetime, I believe that if they disqualify, I'm not sure if it's indefinite. But the risk of losing it alone is detrimental to the defendant. So I just don't understand why this is the route that council has decided to take on this when I would like to know, are there challenges to these arrears? Are they planning on paying? Are there resources being sought? Do they have financial assistance? I mean, these are, these are important pieces of information that is crucial in resolving this case. You can't just brush it under the rug. And then what happens outside of court, Judge? They have a fiduciary relationship, landlord-tenant relationship that still exists. And are they going to offer their assistance to the defendants outside of court as well to resolve their arrears?
Well, I don't know that. You have to say to that, Leslie.
Look, Your Honor, we are the defendant's lawyers. We're acting in their interests. And we believe, essentially, the notice requirement is not just about a notice, it's about opportunity to cure. And so to have 30 days to pay instead of 7 days to avoid having a case filed
But
against
there's-
you is
Right, but here's what the problem is right now. I disagree vehemently with your assessment of the jurisdiction of this court. You know that.
yes, I know that, Your Honor.
And I disagree with Judge Conke's ruling, which is not binding on me.
Yes, we understand that, Your Honor.
Because I don't think it confers that's not how jurisdiction is conferred in this court. And the approach is, frankly, from my standpoint, jurisdiction has probably been conveyed. The question is have you asserted, in essence, an affirmative defense that would lead the court to determine that plaintiff's case would be that is fatal to plaintiff's case.
Yes,
That's the way I look at it.
Yeah. we believe so, yeah.
And I get you guys disagree, but it doesn't matter. I'm a judge. So
To ask the court to exercise its discretion and authority, jurisdiction authority, Your Honor, in determining what's in the best interest of judicial economy and fairness and what would be detrimental to the defendant and prejudicial to the plaintiff.
well, but here's the thing. There's an interesting thing with affirmative defenses. They've asserted it. I've got a rule on that affirmative defense. That, I think, is where it then goes to, is there a way to salvage this without much else going on? And I don't know if defendants are interested in that at all.
Your Honor, we are interested in that.
So let me ask this part, because my belief is that the jurisdiction of the court has been done, and I'm not ruling on the affirmative defense as asserted as of yet. How much is owing on Woods?
What's currently owes through August, $4,188 in rent, $170 in the attorney fees and costs. That's just, we haven't asked for additional costs, Your Honor. And then 4,358 is the redemptive amount. The last payment,
4,300 what?
the last payment that we received on her behalf was on June 9th in 2026.
Okay. And on, hang on, please. And on Smith, how much is plaintiff claim is?
Yes, Judge, I'm showing rent to retain in the amount of $6,915 due knowing through August, 170 attorney fees and costs for a total of $7,085. Last payment received was on 7/1/2026. And I believe there was escrow, but I'm not sure if one was paid with escrow and the other has paid directly to my client.
I have in Miss. How come I do? So in Miss Smith's case, I have no escrow.
Your Honor, it's from the-
In Miss Wood's case, I have 1568 escrow. Yes.
I just wanted to, Min Kim on behalf of Ms. Smith and Ms. Woods. For Ms. Woods, she paid escrow, I believe, for July and August to the court. And also.
When did she do that? Hang on. Yes, she did. So I have another 1568. Is that what you have?
Yes, sir, you have 3136.
Thank you.
And Ms. Woods disputes the balance because they failed to credit her one of her money orders, and she has proof of that. And for Ms. Smith, she paid her July escrow directly to the landlord. She did, which we discussed.
We discussed that the last. I get it. But the balance you gave me is with that credit.
Yes, it is.
So, folks,
Again, no discussions about the merits of the case. If she offered or anyone offered.
look, stop. Everybody just stop. Everybody just stop. All I want to know is this. So, because here's just the practical reality. If I let them assert the affirmative defense, consider it fatal to the plaintiff's case, what ends up happening is the cases are dismissed. Then they're refiled, which seems to me is going to tack more court costs onto the defendant potentially at some point. So,
Your Honor.
folks, are you real quick, Miss Smith or Miss Woods is what, about 1,000 some odd off from getting everything corrected?
Incorrect, though.
What is incorrect?
Balance that's remaining after you deduct the escrow payments is an amount that is incorrect because they failed to credit her a $500 money order, and then every.
Okay, so let's say, okay, what I'm getting at is this. Let's say the money order is there. Let's say somehow you got to litigate that. What my point is, Ms. Woods' tenancy can be preserved. It is so close to whatever, but I don't know whether or not you have an interest in that happening.
Your Honor, we do have an interest in that happening. They're our clients. And so what we propose is that this case be dismissed, that no court costs be assessed because it never should have been filed in the first place. And that
But you're not
the
going to win that because I would be dismissing not on the basis that you view the CARES Act. You might be right if they never invoked the jurisdiction of this court. I do not believe that to be true. So.
And so you'd be dismissing on what grounds, Your Honor?
That you've asserted affirmative defense that's fatal to the plaintiff's case.
All right. And
How? Oh,
so just focusing on Ms. Wood's case for now, Your Honor.
yeah.
It's easily resolvable.
How
And
much?
we can resolve it before
500.
a case is filed, a new case is filed.
Well, maybe.
No, still.
If it's 500, so it's 500. That's at issue. Really? I mean, is that what we have?
Roughly, Your Honor, plus addition of tons of late fees and so forth resulting from that failure. We've been having, we've been having a lot of ledger problems at Haverhill. I think they're trying to correct their books. They've been moving around a lot of rents paid through to a security deposit ledger inappropriately. So this has been causing a lot of confusion for Ms. Woods as well as for many other tenants.
Your Honor, I mean, that categorization, we're here for Ms. Wood's case. I don't appreciate her bringing up all the other cases. This is just, I mean, come on, we're talking about two cases here. Let's stick to the two cases. We haven't even had a conference,
Silly.
Your Honor. I mean,
No, you were even being silly. I'm just trying to figure out how much Miss Woods, I would imagine, wants to have her balance the ledger sat and go on living her life. I don't think she wants to be here, although I'm a pleasant person to be around. She doesn't want to come here and see me. Right, Miss Woods? You all right? All right. Somebody just tell me. Why hasn't the issue regarding um the money order been communicated?
because their only interest was in a dismissal, Judge.
Pardon?
Because their only interest was in a dismissal, Judge. Again, there's nothing based.
We don't need I just don't need the sniping at this point. Where is the money order? Where did you said she had proof of a money order with her right now?
And she has attempted to address it with landlord, and they won't even give her a ledger. This is very common with many tenants that are at.
Well, I don't know about other tenants. I'm just dealing with Miss Woods right now.
She's requested a ledger and they has not received one.
Allegedly.
Okay, allegedly. Ah! Give me all right. Here. This is killing me, Smalls.
I mean, Judge, we're pretty reasonable here. If we were presented with if we were presented.
Nobody's
with the money order, we would have applied.
I just want, all right, look,
I mean, our goal is always.
where's her, are those her money order stubs? All right.
Would you like me to?
Yeah, well, Ann, can we get,
I see them yet.
I know. Give those to Ann and make copies so that everybody has copies. If you're going to object to them, I will give you an opportunity to object to them. Right? I will. So Ann, who can give me a copy of the ledger?
We have a copy in our possession, Your Honor. I can provide it.
Okay, Ann, get that too. Make a copy because I can't do anything with that. Please, thank you. All right. In Miss Smith's case, okay, I have a question on Miss Smith's case. When we were here July 30th, and I'm now in August. I don't know. I got my stamp on that was, you say it was June? Okay. It. Cause what? No. Thank you. No, you're right. Okay. Hold on. Yes, right. Okay. This should have been June 30th. The stamp in the file was July 30th. Okay, so June 30th. And she made. So has she paid rent twice to the landlord or just once? Just once. Okay.
I'm sorry, Judge, which case are we talking about, Smith?
Well, I'm talking about Smith. Okay, so let me ask this. Did you get a ledger on Smith?
Yes, Your Honor.
Okay, so I'm a little bit worried because her balance is up there. And I'm trying to figure out,
Your Honor,
yeah,
we're actually working on multiple fronts for multiple sources of assistance from Ms. Smith. She has suffered tremendous hardship over the last several months.
got it. Okay. Those, I don't want to say this because this is a weird word now with funding and stuff. Are those prospects?
She's been provisionally approved for 4,000 and pending payment on the balance.
Okay,
Yeah, she's
so
also hoping
go ahead.
to be, she had employment lined up, which got sidetracked, and her employer is trying to find another position for her. So we're hopeful that she's also going to be employed sometime in the near future.
Okay, so the provisional approval of the 4, when you say that, she's got to get the other part done, which according to their is about another $3,000. Okay, let me ask this. I get the employment part, but how is that looking in terms of other sources right now?
Hopeful.
Okay.
And if you'd like for, Trish, I can give you more detail.
Yeah, in a minute, but let me just answer this. I'm just trying to get a framework. That 3,000 can somehow be closed, you think? You're working.
Yes, sure.
Because Ms. Woods, you okay? Ms. Smith, you okay? All right. Hey, pardon? It's okay. Don't apologize. You're good. Okay. Going back to Miss Wood's case, I think, with the receipts. Did you get a copy of those?
Yes, that's, yeah.
Okay. And
Oh, they're souls. Oh, did you get the originals of their receipts? Yeah, I know that.
okay. Has she tried to trace on these at all? Or did
Try tracing.
I'm sorry, Tracy.
Did you want to?
yeah. Did you do a trace on these to try to find out if they've been cash?
I haven't traced them to money order.
Go ahead.
I haven't traced the money. I haven't tried to do a
You
trace.
haven't tried to do that?
No, I haven't.
Okay.
But I still have all 4 original money orders.
Oh,
I mean, the stubs.
the steps. Yeah.
So
the
that's
ones
what
that
gave
you
it,
just got
yeah.
a copy.
Got it. Okay.
But I haven't tried to track.
Money orders, I see why. No, okay, I got it. But you haven't tried to
No.
trace through this company to see.
No.
Got it.
Out of the four money orders receipts, three of them are reflected in the ledgers. One of them is not reflected in the ledger, but it does not mean it's not somewhere in there, or it doesn't state who it's made out to. So it doesn't necessarily mean.
I signed everything at the front of the person who stamped them and put her initials on them.
Say that again.
I signed my money orders in front of the attendant at the front counter, and she stamped them with the Hayward Hill stamp, and she initialed the back of them to make sure I had all four.
Got it.
Also tell us which one is not reflected in the ledger.
Yes, the one that's ending in number 1336.
Yeah, we can assist Ms. Woods and help trying to trace that if that's what you prefer.
So how much was that one?
500.
That's a 500. Gotcha. So I'm only, bear with me because sometimes I've got to catch up, okay? So there are four things here, right? But only one of them is at,
Missing.
for you,
Mhm.
right?
Yeah.
And that's the one ending in 36. So it's not looking at all four, it's just got it. Mip, are all of these $500?
Three are 500. One is for the 58. So 1,500. Three of them are 5. One of them is for the 58 because they can only do 500 at a time.
Right.
Yeah.
Okay. So
If I was allowed to pay online like everybody else could pay online with an e-check, I had to go and get my account unlocked because I could even pay from my banking account online because she had to unlock my account in order for me to even pay it online instead of me just going to get the money orders from the store and walking around with $1,500.
okay. So the portal's locked.
She unlocked it last month or when I went to her and said, why can't I pay online?
Okay, so
Now my portal is unlocked, but everything's going into escrow now.
right. And then that means you have to go to your bank and get cash so that you can pay it to. I got you. Okay. So I see a series of $500 credits. And so it, let's see, golly, well. Yeah. These four that you gave me. You took those all in at once.
Yes, sir.
Because
I have the same date on them.
that's how you pay your rent.
Yes, and then the sequence numbers all kind of match, except for just one of them, but all the last numbers match in sequence. Except one. I think one is like off by one number.
They're all.
Well, okay, I see.
That's the last digits of them. They follow in like numerical order.
5, 6, 7, 8. But the next number may not be
Yes.
sequential. So you can't look at the last three. It's not that way.
Yes. So the very last.
The last digit.
Yes, sir.
Gotcha. Okay. So is there a way, I mean, because I'll just tell you what my gut's telling me. My gut's telling me that it's not that she didn't pay. Somebody's missing the receipt of it. I mean, that's what my gut's telling me because she's she goes and gets 4 money orders every time to pay her rent. And I find it a little bit difficult to believe that she then took one of those and didn't give it to the lady. Quite frankly, I had the port open, but we wouldn't even have it.
Portal is closed, obviously, Judge, because it's in litigation, so that is why that's the.
It was closed before.
Hold on. What sense does that make?
That's, it's not uncommon for the landlord for them to lock the portals once it's in court until it's resolved.
Why in the blue blazes would you do that?
I am, Judge, that's.
Blue blazes is a legal term.
But if I may speak, at the time, a lot of the residents, there was a transition of systems, so that's why I opened up the portal. It wasn't that we went in and maliciously blocked the portal. There's a transfer of a new system we're going to, and a lot of people they got locked out. So we had to reopen the portal for people, but it wasn't anything that we deliberately did. But it does get locked out if you have an NSF or insufficient funds or if we're in the middle of legal. That's when the accounting department, the corporate will lock it out. But hers, I don't show was locked out.
I was locked out because you opened it. I sat in your office and you opened it while you were sitting there.
But that's what I'm saying. It wasn't locked.
But it wasn't locked. I just wanted to make sure, ma'am, I was just trying to figure out why were you locked out? And it sounds to me like it's a systems issue as opposed to a policy issue, just locking you out. That's what I'm.
I forget the manager's name. She said that corporate locks the accounts in litigation. Portals in litigation. No, that's what I said.
She did say that. That's corporate. That's has nothing to do with.
Why would they do that?
No, Judge.
That makes I almost said a bad word. That makes no sense. Especially, I could see it if it were a termination case, maybe I could see that. But on a non-payment of rent case, why are we making it hard for people to pay? I don't get it.
I can defer to my client. She knows.
Just the system does not allow a partial payment, Your Honor.
Well, which is also stupid, but I get that. That happens with
which is why I took the initiative to open it up to allow the partial to make it easier for the resident.
Why aren't they just allowing the partial payments? People don't get a big check. All at once, all that money doesn't go into their account all at once. So even if you tack on a late fee, but she can pay through the portal when she has it, right? It just doesn't make any sense. But it's unlocked for you now, right? You can make partial payments.
I put $3,200 in escrow, which is July's,
Right.
August rent. So that's it.
But you don't. Okay.
So
and that's fair. You don't know whether it works because you've been paying to the court.
Because I've been paying to the court. Yes, sir.
Got it.
I knew it, but I did go in and piggyback to make sure it was able to take my card, even though it was a $48 convenience fee to pay with my bank card. I can still go in and see that I was allowed to put my card in.
So they charge you $48?
Your Honor, I've instructed every resident to link your e-checking, which is only $3.90.
Got it. Right.
Right, it's gonna cost you an offensive amount of
Yeah.
stuff.
Yeah, I got you. That's. Do you understand that, ma'am?
Yeah.
That's not uncommon.
I wasn't unable to pay with the e-check even before we had our court. That's when I got it unlocked. But by the time I got it unlocked, I already had paid rent with the money orders.
All right. All right. This one's gonna. So if I take all the money that's in escrow, she's gonna owe
$1,222. But that does not,
$1,222.
it does not include the $500. If that is located, obviously it would have.
I think she paid it. I'm gonna be honest with you. I think something. My gut is telling me something happened on your end, and I don't say that many times at all in cases involving money orders. But she gets 4 money orders and goes down and pays it.
I understand that, Judge. However, again, this is news to us, so this could have been easily reconciled outside of courts. We would have an answer for you now, but we don't, because now we have to go back and trace it. Both sides can trace this money order. And if she needs to be credited that $500, my client will credit her that $500, which would leave her with a $722 bill.
I tried to reconcile the first amount and no one would talk to me about the first amount that you said that I owed. And that's why we're here right now. And things are accruing the way they are accruing because no one would sit down and explain to me where the first amount of money came from when I asked them to. I kept getting dismissed.
Your Honor,
Miss Woods, I hear you. Okay. And Ms. Woods, I'm not dismissing you. All right. That will never happen here. You understand me? So I get that. And you're right. People, you're trying to just do your business and people need to respect that and they need to talk to you. I hear you. How was, and I guess I'll ask counsel, how was, if she were to get the credit for the 500, how the 722?
Well, Your Honor, we think that they should also waive the late fees and the other charges, the $48 charge, because it was impossible for her to pay otherwise.
Well, it's not in the $48 convenience fees, a weird thing. I don't know what I quite do with that because it's not something where that's not an uncommon thing in the system, which is why she's saying link your e-check. And I don't know, I'm not even sure why there shouldn't be a fee on the e-check. Because they're going right.
It's being wired directly to their.
Yeah. Whereas I get I mean, it's crazy that it's $48, but I get it. I get that.
In Your Honor, that wouldn't have brought her to a zero balance. So
What would have brought her to a zero?
they were asking to waive late fees, so on and so forth. The late fees automatically accrue unless there's a zero balance on the account. There was no zero balance on the account. Even if we were to credit that $500, it wouldn't have been a zero balance. She still would have had a balance. And so those late fees are appropriate.
Well,
Your Honor, I have never been told that there was a missing money order. I do not dispute that that could be the case, but this is the first I'm hearing of that.
I know.
It could be they didn't put the right unit number. It's easily.
The right one?
It could have been the wrong unit on this money order. I was never told that.
Gotcha. I got you. No.
This is the first I've heard of this.
No, I Thank you, and I appreciate that. I get,
Residents. But I wasn't told this till today.
and no, I get it. I'm not saying that you wouldn't have done something. It sounds to me like when they come talk to you, they're heard. I don't think what she was saying was really necessarily directed at you. Something tells me, because you're the one that got the portal unlocked. How much do you have? How much are late fees for you guys? That how
50, 50, 50.
so what would be the total amount of late fees that you're looking at?
I see 5 months at $250.
200 or 250?
255 months.
Got it.
I'm sorry, Judge. I'm gonna have to object to any waiver of any late fees because of the fact that, again, the last time she was adding zero balance was
You know what?
in March of 2020.
Okay, I get you object.
The client is within the right to collect pursuant to anything that's within the lease, Your Honor. And so
You want me to go through an analysis regarding your late fee, because your late fees have to be accrued to your client efforts in attempting to try to collect rent.
right.
If I were to find, and I'm gonna tell you, you can talk to the people at McKinley, because I went through it. If you want me to order that, I will. It will be a nightmare for you to get the information to me that you want. I just give you that warning, counsel.
I guess so respectfully, Your Honor, the court is getting frustrated because,
I'm not frustrated.
again, Your Honor.
Trust me, if I were frustrated, everybody would know and run. I am not frustrated.
So I believe that this case could have been resolved outside of the court's, without the court's intervention and.
Well, I'm here now.
And we can still do that, Your Honor,
Okay,
if they're amenable to a resolution.
everybody needs to just stop talking. Because all I'm trying to do for right now with Ms. Woods is this. And I'm making my thoughts rather clear. I think she paid the 500. I think the 500 is just not, it's missing somewhere. It may have got, I don't think anybody tried to do anything intentional. I'm not saying that. But the way she would pay her rent, in my experience, somebody doesn't show up with 4 money orders and then keep one. Right? That doesn't happen. And then keep the one that sequentially would be in the middle of the other two. None of that makes any sense to me. Yes.
Correct.
Yeah. I just, so it's, no, I get it. I get it.
Gonna find around the same time, which would have been a $500 difference in her balance, which at that time, if it were received and applied correctly, it would have been, she would have still had a remaining balance of $462 if that $500 was applied.
Okay. Here's the deal. All I'm trying to do, Miss Woods just wants to get to 0. Right, Miss Woods?
Yes, Your Honor.
And then that way she can figure out how to go on. Now that the portal's open, she can figure out all of that. She can get her rent paid. We don't run into the money issue. So all I was trying to get to was that she's at 720. If the 500 comes off, she's at 722. Then there was a indication regarding late fees, right? So if I just momentarily say, she's at 722, and let's say I just take 200 of the late fees. Say right now, I'm not going to worry about them. Then I'd have to ask you, could you come up with $522? Or let me say, when could you? Better way.
2 weeks will suffice.
Pardon?
2 weeks will suffice. 14 days. If I can get 14 days, I could come up.
Pardon?
14 days.
Could you explain to me again how you come up with 522?
Because what I did, she's at 12, they gave me a number 1222. If I say I take the 500 off, right? Because I think she paid it, we just have to figure that out. Then I'm at 722.
Is that court cost and court fees?
Hold on, just a second. So then I'm at 722. Then I said, okay, there's $250 in disputed late fees. At some point we'll have to figure that out. But if I take 200 of that, and I just take 200 of that, I came to 522. And then I asked Ms. Woods, how long would it take you to do that? And she told me 14 days. It's
So
funny.
you're
It's
not-
funny with all of these lawyers in here. The only one that was following me was Miss Woods. Go ahead. What?
I just wanted to note, counsel just stated that if the $500 had been credited, her balance would have been 462. That would have been early June.
Early June. Okay.
Original balance.
462 in early June. And then I see in July, they charged her the 568 plus a $50 late fee. That 568 went into escrow. In August, they charged her 568, and this ledger says $40 in August late fees. That was put into escrow.
1568.
So,
Plus 40 in August. And so just from this ledger, it seemed to me that her balance is more like 462,
for what?
462.
We're right. And actually, had I taken the whole 250 that you disputed, I think we're at the same number.
I think it would have been even less because that.
No, so when you said you disputed 250, I just rounded to 200 to see where she was in terms of funds.
Mhm.
I didn't take the 250 off. If I take the 250 off, I'm at 722 minus 50. No, 722 minus 250. Hang on a second before you say anything. 672? No, you can't get
470.
472. What'd you say?
472.
472.
Which is we're $10 difference.
Yeah.
That's what I'm saying. Had I taken the whole 250 that you're disputing, we'd be talking the same number. Basically.
Yeah, I don't know where council's 1222 number comes from, but we are.
Balance. That's the balance that she owes less escrow. That's where we started from. That's where the 1222 comes in. And then the 500 is, then you take off 500 of the money order. And then you got $250 of disputed late fees. Part of those late fees I may be able to solve right now. Did you charge her late fees for July and August?
Yes.
Yes. And
That's the $50. Those come off. She paid her money into escrow. There's no late fee.
I'm wondering, I mean, we might be looking at different ledgers because the final balance on this one that we just got from council is 4188. And when I subtract, I believe it's 136 in escrow, I get 1052.
That's before the attorney fee.
And we don't believe there should be attorney's fees.
Of course.
No, I know. I hear you. I get all of that. And folks, somebody's going to have to move on the numbers. If it's going to get resolved. Miss Wood's case is so close.
Your Honor, we agree, but we just want to say that you can rule today that you're denying our motion,
Or I can not rule at all
but if
today.
if you render a judgment, then you've denied our motion.
If I do what?
If you render a judgment, then you've denied our motion.
No, that's not true. That's what you would like to think, but that's not true.
We've moved for summary disposition. We don't have a ruling.
You're right.
And so you can't proceed to judgment unless you've denied that motion.
Have I said I'm issuing a judgment?
Are you?
Oh, when I'm issuing a judgment, you'll know.
Okay.
I'm just trying to figure out how to get her to zero.
And we know that we're close, Your Honor.
And here's what I'm saying. By default, the case gets dismissed, frankly, with another payment without a judgment. Because she would have zeroed. That's what I'm saying. And then Miss Woods can just go on and not have to talk to me, you know.
And absolutely, if that's what she prefers to do, she's our client, we will accede to her wishes.
I mean, but you understand what I'm saying, right? So,
I understand what you're saying. My only thing was when I originally was told that I was owed the 352, and I asked her where did it come from. No one explained to me where it came from. But when I pulled out my security deposit payment program, 352 was the last part paid for my security deposit. The exact amount was what they told me I owed. They transferred from my rental account all my money over to my security deposit, which made me pay over $250 for a security deposit that was only supposed to be $2,350. That's why you wanted to see the case again, because when I told you that I didn't believe that I owed that money, it was like, okay, well, we need to see the case again so I can check.
I remember.
Yeah.
I can speak on that, Your Honor. And I took over Haverhill in April.
Lucky.
Yes.
Yeah, go ahead.
My observation was when they moved in, a lot of the residents weren't understanding. When they paid their monies, it sat on the resident side. It was their deposit with their intentions of having it be that. So when they would look at their ledger, they would think they had a credit. Once the accounting moved it over to deposit, that's when you would start to see then the negative pop up on that. So that's the first thing I saw. The other thing that I can honestly say, because I've experienced it, when I'm being cursed out, staff is instructed not to speak to anyone. I've been cursed out despite my motives to try to resolve with Ms. Woods. I've been cursed out. At that point, we disengage, Your Honor. We're just not going to stand there and be there.
I have never cursed you out. Yes, I have became angry, but please do not stand here and say that I have cursed you out, because you would have called the police on me and had me escorted out of there if I was to cuss you out. You would have not just allowed me just to cuss you out freely and just walk away.
I should just cuss everybody out here. Thank you. Yeah, I'm sorry.
Despite the effort that I tried to resolve, sometimes we don't engage in person.
No, I get it. I understand all of that. I think folks, you just have to realize from my standpoint, week after week after week, I see folks that are so far behind, it's hopeless. And ultimately, they're at some point. I'm looking at Ms. Wood's case and I'm just, maybe I get happy because it's just not that far off and she can be at zero and everything can be okay for her. That's what I'm saying. And I don't. The months outside of the last 2 months, the months for the late fees are what months, Miss? Weekly?
June, July, August,
April, May, June,
August.
April, May, June. And that's when you paid with money orders, ma'am? I'll tell you what. Somebody needs to find that 500. Here's what I'm going to suggest to the parties, just as a framework to try to resolve this. I'm going to adjourn any ruling on this matter to just give me a Friday.
Oh, you want Friday?
Well, when's my next Tuesday?
August 25th.
Oh, all right. I'm adjourning any ruling on this case to August 25th. Okay. That's a Tuesday. I am inclined to, and I'm doing this just as a framework for the parties. I am inclined not to waive all late fees because she was bringing everything down there. And that in and of itself is a hassle, right? I'm inclined to believe, although you have to find it, that the $500 was paid. I'm inclined to split any costs that would be associated. Right down the middle, 50%, one way or another way. I think at that point, if you come up with a number from that, I think from what Ms. Woods told me, 14 days from now, she could have that paid and be done. So your case, ma'am, I'm going to adjourn out to the 25th. Let your attorneys work with the other side. They kind of got my framework of whatever. And that's it. We can just be done.
Okay.
Fair enough.
Thank you.
Thank you.
Thank you. On come on, girl. All right. Now your case is a little bit more. You said you were on that you had the provisional 4,000. Is that through Hawk or is that through?
The Emergency Housing Fund.
Got it. What are the prospects of the gap with the 3,000 being closed?
These were responses on two sources and hopeful, but if for any reason the funding is not available, you know, we believe they would assist her in relocating.
Okay.
With time, I mean, you know, oh, she has to put in applications, etc. So
Ms. Smith? You gave up hope there for a minute, didn't you? When you heard that, right? So let me ask you this. Why are you giving up hope?
It's like, it's giving out. I'm scared. They just been trying to transfer departments at my hospital because I had a cardiac episode and they fired me from that department. And so I'm trying to work with HR to get into another one. I'm not well. And I have a disabled daughter that I'm trying to protect. And this is the safest place I've ever been. I don't want to lose this home.
All right.
I care about this place so much. And I'm trying everything I can. I don't have parents or anything. I'm alone. And I am not, I want to pay them. I want to pay my bills and I want them off.
I know you do.
I feel like I'm dying. And I am in therapy, but it only does so much. It does not pay my bills.
Okay. All right, Miss Smith, a couple things. You got a lot going on. Sometimes one always has to look at, you kind of have to put things in order, right? Because we all have our lives and we can't deal with everything that's coming at us.
Very overwhelmed.
Huh? I know. And I can tell. And thank you for sharing all of that with me because I didn't know. Okay. Let's try to do this. Let's try to take one step at a time because we're trying to grab everything, right?
Yeah.
And that's where it all kind of gets overwhelming. Right?
So that's a bulk line, yeah. It's
What do you say?
Fix everything at once. I'm learning to not do that.
I'm the same way, and I had to kind of back up, right? So what I'm hearing in this case is there's 4,000 that may be out there. We're trying to figure out the 3,000. It gets scary, and I asked the question, counsel was answering me. It gets scary when all of a sudden, if that falls through, then we got to do X. But we don't know whether we have to do X, right? So at this point, we're not going to worry about it. Okay. And what I'm inclined to do, would the time work to try to figure, will you be the 25th? Yeah. Would you be able to have an answer on that other piece, you think, by then, or? Hmm?
Well, this has been human for a long time.
Then I'm going to adjourn this one out to the 25th also. And
Yeah.
Are we looking at morning or afternoon?
that is morning. Okay. And Miss Smith, you got a lot on your mind. All right, listen. Okay. Regarding this issue, and this is the great thing about me and me. Okay. Yeah. What you say? Well, thank you. But I want to tell you this, and it's true. I want you to worry about you got good lawyers here. I want you to worry about the other stuff you've got going on. Work, your job, your health, your daughter. I want you to worry about that. Okay? With regard to the case, they got you on that. And the other thing is, plain and simple, nothing happens until I say it does. So you're not going anywhere right now. Okay? So I don't want you worrying about that. Okay? All right. And I'll adjourn it out to that date. We'll see you on the 25th. We'll get a better handle on the funding part of it. And
I won't give up. Thank you.
what?
Thank you.
Don't you dare give up. Because then I got to go out, got to get Alan, we got to go out, we got to find you and everything. And we got to like have that whole conversation. We don't want to do that. Okay. You're welcome. All right. We'll see you guys in a couple of weeks.
Thank you.
Thank you, God.
Sorry, the money orders that were provided, can we see the back of one of them? Just so she can go back to the office straight.
Did she leave?
No, she had to go.
Oh, okay. She had to go to work. All right. Yeah. Take care of yourself, okay? You're welcome. All right. This is what this one.
You just have the one with two left, but I have not seen Anderson's counsel yet. I don't know that he's here. Where is it?
Anderson, is your attorney here?
Yeah.
He's on the way? Okay. Court is standing in recess.
All right.
Think that?
Yourself.
Okay.
All right. I don't know what that is. We're getting back feedback. All right. Mute them until.
Yeah, they're muted. They're unmuted. Muted again.
Okay. All right. Just stay muted, folks. Get feedback. I have before me a conditional order dismissal.
Would you like the terms on the record, Your Honor?
Yes, sir.
Your Honor, we have agreed to resolve this case. It's dismissed without prejudice, subject to the terms of the order. The defendants still surrender possession of 442 Village Green Boulevard, apartment 101 on or before August 26. They shall pay all rent, fees, and other charges to plaintiff when due, including court costs of $220. They shall not smoke tobacco or any other substance in the leased premises or within 30 feet of any building in the Haven. They'll comply with all the terms of their lease. If they do that, vacate and surrender possession on or before if they fail to do that or fail to comply with the terms of the order, we're entitled to immediate judgment for possession with an order of eviction. And the judgment may be a money judgment if any sums are due and established by affidavit. The 14-day provisions of MCR 4.602 C2D are waived. The terms and conditions of the lease remain in effect. There's no waiver of rights under the Landlord and Tenants Relationships Act. This order is a settlement. It's not an admission of wrongdoing or finding of fault. And would you like me to handle MCR 4.201J?
Yes, if you,
Ladies, because you're not represented by an attorney, you have 3 days to ask Judge Simpson to set this order aside. It has to be for good cause, such as you didn't understand the rights you were giving up by entering the order. You were coerced into signing it. I misrepresented the terms of the order or some other substantial right. After 3 days, this order will become final if no motion is filed. And Your Honor, this is a final order resolving last pending claim and closes the case subject to the rights of the plaintiff.
all right.
We have all signed the order, as you see by the dates.
Yes, and so I need them unmuted now.
Hello.
Folks, is that correct?
I can't hear. I'm sorry. Maybe you can hear me. I think I'm unmuted. Hold on.
You're
Oh,
unmuted.
yes, sir. Okay, thank you, sir. So we're all dismissed and we're set to go, correct? And I will follow the orders.
Yeah. Was everything that Mr.
stated?
I don't think so, sir. We kept cutting in and out. But I do know the terms of the agreement. And we're going to be vacating our apartment on August 26th.
All right, and
All
you
right,
understand?
and you understand disregard smoking,
Yes, sir.
And you understand?
and you understand
that this becomes final?
this becomes
3
final
days,
3 days,
unless you file a
unless
motion
you
to
file
set
a
it.
motion to set it.
Yes, sir.
You understand all of that?
Understand all of that.
Yes, sir.
All right. Do you guys
All
have
right, do
any?
you guys have any
whatsoever?
I don't, again, you're cutting in and out, but I think I'm understanding what you're saying, sir.
Right. I'm just asking. Do
I'm
you
just
have
asking,
any?
do you have any?
We don't have any questions, sir.
Fantastic. Thank you.
Fantastic, thank you.
Signed
So we're
it.
all set?
Signed it.
It's this condition
It's this
dismissed.
condition
You are all
dismissed.
set.
You are all set.
Thank you, Judge
Good.
Simpson.
You're welcome, ma'am. Good
Well,
luck to you.
ma'am, good luck.
Is that what it is? Is it us? No, I don't think I am. Mine is saying join audio, but it's mine is not normally connected.
Yeah, be excused.
No, I mean, yes. Thank you, sir. Showcase Investments versus Sergey Berlanga.
Good morning. Good morning, Your Honor.
I don't know. See you guys show up. It may not be a good
Well, let's hope it's a good.
Okay, all right.
Just hope it.
Good morning, Your Honor. Melvin Baby on behalf of the defendant Berlanga.
All right. And where are we on this?
Your Honor, our motion still stands. We're seeking to set aside the default.
All right, response.
Well, the motion fails cause, let alone good cause, why the defendant didn't take any action against the judgment for 90 days or participate in the case. There was personal service, Your Honor. There was even a courtesy copy to defense counsel. And after entry of the judgment, email exchange. So there was actual knowledge of this hearing, and yet no action taken, and also no explanation, excuse, reason, or otherwise. So it fails under 2603, failure to state cause. Also, Your Honor, there's really no defense to this case. There's a title discrepancy that was raised, a prior action that was raised. The prior actions in the past, it was settled. I wasn't even involved. That has nothing to do with this case. There was a balloon payment that was part of that settlement that was missed. Parties acknowledge that. And a title discrepancy that was raised. However, it wasn't raised until the 11th hour on July 20th. And then by July 22nd, a quitclaim deed was drafted and ready to be conveyed, which actually has been signed and notarized and recorded as of, was signed on July 23rd. So that affects the conveyance and recorded on the 24th. And all of this is all public record, where the parties have been engaged as first as a landlord-tenant relationship that morphed into a land contract vendor-vendee. You have a clear vendor with a contract that had a balloon payment, a judgment that was entered by default.
I don't mean to interrupt you, counsel, but are you indicating that there was actual notice of the April 24th hearing given to counsel?
There was, yes, a courtesy copy. Before I served defendant, I asked defense counsel if he would accept service and emailed him a copy of the summons and complaint and the land contract. And when I didn't get a response and having the hearing coming up, summary proceedings, I sent a process server out to serve the defendant and had personal service on the defendant. So yes, there was knowledge of it.
What about that?
Thank you, Your Honor. This matter, at all times, my client intended on redeeming the forfeiture. So my client didn't participate in the forfeiture action because it didn't have an issue with redeeming or challenging the forfeiture. This matter is before you, Your Honor, because at the time my client sought to redeem the property, it turned out that the party that proceeded before you, CourtCase, did not have authority to enter into the land contract, did not have authority to initiate the proceeding, did not have authority to obtain the judgment it obtained. And when this title issue was brought forth
Saying they didn't have the authority, what do you mean by that?
I mean, CourtCase was not the owner of the property.
Who was the owner of the property?
The owners were two individuals, the last name of Mehta and Gotcher, on recorded deed. So they didn't have authority to present to this court the ability to seek forfeiture. Now, Your Honor, we didn't know that at the time they initiated the forfeiture action. Otherwise, we would have prosecuted it. We brought this before you because at the time we sought to redeem the property, the lender participating in the redemption declined to fund the loan because they said CourtCase doesn't own the property.
Okay.
Declined the loan.
So-
Now, my client has
Hold on.
this.
Who owns the property?
So what he's referring to is a conveyance to the two owners of CourtCase. And there was
There's a conveyance by who?
by CourtCase Investments, LLC, the land contract vendor, to the two principal 50-50 owners of CourtCase Investments. And
When did that occur?
that it goes back to before I was involved, back when Mr. Babby was involved in 20.
Prior to me being
So-
involved as well, 2021, I believe.
So then how is this brought in the name of CourtCase?
CourtCase Investments is the land contract vendor on the contract. And had this been raised,
Yeah, but hold on a second. It seems to me then, that was part of my confusion here. It seems to me that these two individuals, if one agrees that there was this conveyance, they took subject to that land contract. But they're the owners of the premises. And so I don't think CourtCase can't, while their name might be on the land contract, CourtCase can't bring in action because they don't own it. They don't have any interest, is what I'm hearing.
well, had this been raised, it would have been conveyed back to CourtCase as quickly as it was when it was raised on July 20th. They had an ability to convey, Your Honor. They've shown an ability to convey. And this was raised in circuit court action, TRO. it was found that there is this ability to convey. Now, why wasn't a title search done? And this email that's attached where the lender raises this discrepancy, there's redactions, there's other issues with this matter. There's more to it, Your Honor. The land contract is from years ago. The balloon payment was due at the end of 2025. And this through due diligence, this could have been raised so that we weren't prejudiced at the eve of the expiration of redemption.
And Your Honor,
But paragraph 2 on the complaint that was filed in this case isn't true. Right? So when this action's brought, what is Showcase's position vis-a-vis the property? They don't have any
They don't have an interest in the
in the property nor the contract, quite frankly.
but they could show an ability to have conveyed it back. And we would be
They could show an ability to have what?
conveyed it back because it went to their owners. So there was
No, I get the transaction, and some of this may be, I won't say form over substance. I mean, there's a reason why certain things have to be done a certain way. But the correct statement in paragraph 2, well, no, because I don't know how Showcase, I'm going to have to agree. I don't know how Showcase brings this action. That's kind of where I'm stuck.
my client brings to my attention that there is a management agreement between Showcase and the owners. So they have the ability to manage the property.
Who has the ability to manage?
Well, Your Honor,
No,
let me hear.
No, I mean, if there's okay, go ahead.
My dilemma here is that this could have been raised on April 10th. This could have been raised 3 years ago. But defendant waits until the 90th day to bring this to the court's attention without stating any good cause. And I would submit to the court, this was an innocent mistake with an intention to convey back what I'm being told upon information and belief from my client without any intention, and there was no specific allegations of fraud to grant relief from judgment.
I'm not even, I get that. That's the furthest thing from my mind, because I don't believe that anybody was trying to pull the wool over anybody's eyes. Anybody was trying to do any of that. I have a complaint that lists Showcase as the plaintiff. Now, with the management agreement, I don't know what that says. There might be a way that one could deal with that. Maybe. I don't know. But then the problem is paragraph 2, which indicates that Showcase is the seller.
and Your Honor, if I may, this issue, if set aside, does not prejudice the plaintiff to the effect of refiling and having another 90 days to get paid. On the opposite end, my client's prejudiced by having invested over $105,000 into this property, his family's home that he's at risk of losing because of their mistake.
May I address the paragraph 2 briefly? Under the land contract, Showcase was the vendor. And on the information available at the time of filing and the contract that's attached, it was the vendor. And in response to defense counsel.
Correct. I'm not disagreeing with any of that. At the time that all of that was entered, what I'm saying is at the time of the filing of the complaint, 2 individuals owned it and were really the assignees of the seller.
And also the principals, owners, 50-50 owners of the seller.
I hear you. I'm not, none of that am I disputing. I run into this with LLCs all the time.
To talk about prejudice, to sit on your hands for 90 days and raise this when this was a public record that could have been determined. And I still haven't seen a title search. The email that purports to be this defense so that the loan couldn't close because of this, Your Honor, it has redactions and other issues. The plaintiff can show that it was ready, willing, and able to close. And if we have to refile, and that's the court's decision, I'm fully respectful, but I just, in closing, would say that there's been no explanation why we're sitting on this for 90 days. And that's the prejudice without any payment since December of 2025. And now we're in this impasse where I'm sure Mr. Berlanga would like to get his loan, but if he doesn't, are we just kicking the can?
So why am I here at this point?
Your Honor, at the time we obtained financing and we're seeking to close, we obtained a title report. We obtained the liens that needed to be paid off, which were liens owned by the principals, Meta and Gotcher. It wasn't our obligation to go do a title search at the day of. We relied on their representations in the land contract. We assumed at all times Showcase was
but
the
why
proper
are
party.
here?
Because my client's going to lose his home because he was unable to redeem due to the mistake by plaintiff.
And my
In other
response
words,
is
my client would have redeemed the property. My client is still seeking to redeem the property, but at this time, the redemptions technically expired because it was obtained by an entity that had no authority to initiate the proceedings, initiate
Well,
the
let me
judgment.
guess this, just plain and simple. Are your clients willing to let them redeem the property?
absolutely, we just don't. We've been sitting on this.
And then
We were ready.
That's not
to
true,
be
Your
able
Honor.
to close.
Your Honor, we asked for a 30-day extension because of their mistake, and they told us no. And we said, this is reasonable. It's your mistake. Give us 30 more days so we can go back and correct the issue with the lender. And they told us, no, we're pursuing to obtain possession. So again, my client's going to be significantly prejudiced.
I'm just asking. Your client wants to redeem the property.
Absolutely.
And basically pay off the land contract.
Absolutely.
Your client wants the terms of the land contract fulfilled, the payment, and then transfer of the property, or no?
Yes, but that should have been done. To answer your question,
I know there are a lot of things that should have been done at a particular time. Sometimes if things are done timely, I don't have a job.
I think at this time it's a no because we've already been through due diligence. This could have been
Hey, but
discovered.
The
and we're
problem
past
with
that.
that. All right, and everybody just think from a practical standpoint, because I haven't ruled. If the practical reality is that if I grant their motion, you start over and then there's a redemption. And if I don't, then you're stuck, right? I mean,
Correct, Your Honor. And they obtain a substantial windfall, at my client's expense.
no,
I don't. I have to.
I don't know that that's the case. I
We're
think,
forcing the contract, if any.
yeah, I mean, people are trying to attribute fault. I don't think that I don't see that case this way. Now, people might be evil on each side. I don't know.
No.
But I don't see that case this way. I don't think anybody was trying to do something fraudulently by filing it in this name. I think that's just an error in a lot of ways. It's an LLC where the principal owners transfer it back to themselves. It didn't transfer. There wasn't some like bona fide purchaser that did something, or it just isn't that. It happens all the time in this court where I have LLCs or I have partnerships, and the folks that are part of it don't understand that they may be an entity. So these two are their separate entities, but this other thing is an entity in and of itself. So I get all of that. And I don't think anybody's trying to do anything. I don't think that somebody's trying to take a substantial windfall on something that they may not be entitled. But I'm just trying to figure out, before I rule on it, where are the parties on this? Because it seems to me your folks want to fulfill the land contract, pay it off, and your folks want to accept it, we can be done.
They've been having that conversation since before I got involved for years. And now I've been involved January, and the same old story, Your Honor. So I think at this point, the plaintiff is fatigued from the time that's elapsed. If the court's inclined to grant any type of relief, we'd ask for cost allowed in the rules. But I also think if there's a creative solution here where, let's say, 30 days is given, we'd ask for some sort of escrow payment or some sort of protection. But not that it, no, it's the plaintiff's request that an order of eviction issue, and if not,
Are they going to be able to close over? Are you going to be able to close over the title on the property?
it's the plaintiff's
I'm
position
on-
that title can be conveyed, and the circuit court did not disagree.
That title can be
The plaintiff showcase can show an ability to convey title to Mr. Berlanga and could have during the redemption period. I think there's more to this loan.
Because I hear you.
Yeah.
I hear you.
All right.
Could have operated, but now I'm here,
Yes.
right? I mean, shoulda, woulda, coulda. But I can't go back. I'm just trying to figure out if there were a solution where within the next 30 days you close on this. Can title be conveyed satisfactorily to defendant in this case?
Upon payment of the total balance, the mortgage can be paid. Yes. Title. Yeah.
Right,
The answer to
but
that question is yes.
my issue isn't the payment. I'm assuming there's going to be a transfer of funds. I assume that. What I'm saying is what seems to be the holdup is when they do the title search, the owners of the premises are not showcased. So all I'm asking, whether it be by insurance, whether it be by some affidavit, however it would happen, a transfer back in the register of deed, I don't care how it happens. How are they going to close over that defect?
It's already been done.
What's been done?
It was done on July. It was already done, and it was sent to opposing counsel, and he did not send it.
What was done?
The conveyance back to Showcase. Showcase, as it stands, Showcase has title to this property.
Jesus. Are you kidding me?
What?
You've already conveyed it.
The quitclaim deed is attached to our response as Exhibit C.
Yeah, but did that get filed with the register of deeds?
And recorded
Okay, so
by the 24th.
And it was recorded on the last day of redemption.
But we could have closed.
Again, Your Honor, their mistake shouldn't be my client's.
Oh, I have to disagree with that because under due diligence,
It's not our obligation to do their
Any
due
buyer,
diligence.
their due
We
diligence.
relied on their, Your Honor.
I told you it'd be a good morning. I tried to make it a good morning.
Your Honor,
talking, it's good to have somebody up here that talks.
Your Honor, I agree with you. We always look for a practical solution. In this case, I think the practical solution is to just allow my client to redeem. He was unable to redeem because of their mistake. We're not asking for anything in addition to.
So
the
when's
right to-
that redemption gonna happen?
Your Honor, at this point, my client has to go back to the lender, they have to go review title again, and they have to review his loan all over. Lenders don't move fast. They do not move fast unless you're working with private lenders.
Hold on a minute. If so here's the problem with that. You're right. Some lenders don't move fast, but at the same time, everything, if what you're telling me, and I don't have a reason to dispute it, had been happening toward basically closing, then the only thing that needs to happen is basically the title search. But already part of that's been done.
Your Honor.
So that shouldn't take long at all.
I can't speak for lender requirements, but they're going to reevaluate him based on a new application.
I mean, the
And
title
so
Why does there have to be a new? I don't get why there has to be a new application.
I don't control the lender. I'm just asking to make sure that I have sufficient time to go back to the drawing board to allow my client to redeem for the issues that were not caused by my client. That's all. And again, that's the practical solution. I offered it before we came to this court. I offered,
Here's the thing, counsel, and let's be real about this. That comes up during a closing. You could have gotten satisfactory information that the two individuals that owned it really are showcase, and could have paid an insurance policy to insure over that title defect. You certainly could have done that.
that I don't know a title company that would insure over the.
Oh, absolutely.
Without having a operating agreement from Showcase, without being able to validate the owners of Showcase. I mean, we don't have any information showing who Showcase is, who the members are. This is just brought today. So there's other issues that come to, that would come to.
Your Honor, in response,
In closing on property, that happens all the time.
may I respond? Briefly.
I handle a lot of property.
Go
Actually,
ahead.
Your Honor, I
At closing, the title company asked for the Showcase Investments operating agreement, which was disclosed early on. So this is, a lot of this information was available early on, and that's the only statement.
What do you guys want to do? Because so here's the thing. If I were to put this out and tell you convey the property, give you time to have that happen, because that ultimately was, I think, what the parties were trying to do, and I think everybody's just mad now. And I were to put it out 30 days, what you're telling me is you're not sure that this is going to go through.
No, I'm not saying that's not going through. I just would want sufficient time to make sure I don't have to come to you again, Your Honor. That's all. And I don't think it prejudices the plaintiff to say 30 days versus 60 days. And if the escrow payment to the plaintiff would accommodate them for the additional time, I mean, we'd be willing to do something like that. But it doesn't prejudice the plaintiff to say, you didn't have authority to initiate the proceeding. Set aside.
I quite, when I'm listening to your argument, think that something else is going on.
I'm not following, Your Honor. I guess what I would say is my client doesn't have the cash in his bank account to go pay the plaintiff tomorrow.
So I get that.
Yeah, that's all I'm trying to say.
Something else seems to be wrong. Because your client wants an opportunity to redeem, but isn't giving me a time frame upon which that's going to happen. And so I'm trying to figure out what's up with that, because the other thing is, yeah, you went to a lender and the lender is, what I understand, is all willing to go forward with everything until the title search is done. And then there's this glitch. So I don't insure over it. Okay. And that would mean to me, everything is done for this loan to go forward. I just have to correct the title. But now you're telling me that that's not.
I'm just saying there's factors outside of our control.
It's just a correction of the title. And now what I'm hearing though is everybody has to start over, which is just kind of weird to me.
I would say the lender only. On the lender side to apply for the loan. That's all I was saying, not title. I think the title works.
No, but counsel, that's what's bothering me. I'm not clear why there has to be a new application.
I'm assuming
what happens,
Your Honor.
Moving along.
I could be wrong. I'm just assuming there would be. I haven't worked with.
Morning. Filling up. Now there are two of you, and I don't have to deal with either one of these.
Hello, Jimmy. Good morning.
But counsel, I'm. Did something in your client's financial position change? I mean, because
No.
but it's
No.
Council, that's what it sounds like to me. Because what it sounds like is I do the application, we run into this title thing. The title thing is a real thing, probably, certainly. And so I'm not saying that it's not, but
I understand
the
where you're.
title things is not what stops this deal.
I guess my gripe is that I offered 30 days to correct their issue, for them to correct their issue, and I think we can get it done in 30 days. He forced us to come here, and ultimately,
Oh, welcome.
Showcase didn't have authority. The mistake they made should be grounds for setting aside the judgment.
Counsel?
The fact that they
Let's just talk practicality.
and
I get
I am
the
trying
legal
to.
issues.
I get.
I'm just talking the practicality. Can your client do this?
Correct. Yes, Your Honor. Absolutely.
Your Honor, if he needed 30 days on July 20th, but now needs 30 to 60 days on August 11th, and has taken absolutely no action with the lender in between now and then, just sitting on his hands.
Well, I don't know. Did he? I don't know if he did or not.
Sounds like they're starting from scratch, which this should have been done at the end of the year.
Yeah, I shoulda, woulda, coulda. I get it.
Yeah.
I'm just trying to figure out if I were to give you 30 days, now that it's been transferred, is this going to happen, or am I going to be here 30 days from now, just looking at this file again and having to listen to you two?
Well, it's part of the reason why we declined the extension, because we figured we'd be here an hour later. So we may as well enjoy a Tuesday morning with Your Honor and get a decision.
Enjoy is a funny word. But anyway.
I guess, Your Honor, I was always willing to have 30 days to allow us time to close.
Let me maybe ask it a little bit. Is your client starting over financing?
I guess I don't understand. Is he going to be reapplying for the loan? It's whatever the lender's going to require him to do. I don't know if the lender's going to require.
Are we even dealing with the same lender?
Yeah, it would be the same lender.
And you're telling me his financial position didn't change, but they're requiring a new app. I don't get it.
Loan applications, to my understanding, expire at 30 days.
I mean, they'd have to update information, but this doesn't. How much? What were the monthly payments?
There were interest-only payments.
My understanding it was 1995.
Pardon?
1,995, I believe.
There were interest-only payments.
For interest-only payments, nothing on principal and related interest, insurance, and taxes and insurance included.
So based on the land contract I'm looking at, I think it was 1,259.37 plus taxes and insurance, which I think came up.
Say again.
$1,259.37 plus taxes and insurance. I believe the taxes and insurance were $636.38.
Totaling $1,895.50 of interest.
$1,895.
$1,895.50. That's interest and taxes and insurance.
And me 890 times 2. I have my own calculator, but they won't let me have one now.
1895. 3,791.
All right. So the redemption period expired what day?
It would have been the 90th day would have been 23rd of July, April 24th. That man.
So, council, the buyer, well, it's August, and then I'm gonna be I'm in July. Oh, if I said to your client or said that I would just postpone this motion for 30 days, give you an opportunity to redeem the property. But to do so, he would need to deposit $5,686.50 into escrow. Could he do that?
When would you want that placed into escrow, Your Honor?
Probably even as we're speaking, but when can is that even going to be a possibility?
I can add, give me an opportunity to discuss with my client.
Was that number 568650?
I have 5686. Okay. But client,
Very nice.
your client's here.
Yes.
Where? Oh, because these two wouldn't move. All right. That was weird. All right. How are you guys doing today? Hold it. You're not using you. Right? Yeah. You?
What?
How come? What time is
Your Honor, he said he would
Hold on a second.
request.
10:22. You guys should have late.
Yeah. I did actually look in.
Hold on a moment. We'll get out of this conversation. Really? Okay.
I did.
You showed. Is it late?
Yeah,
Or were you
it's
going time?
No, like 10 minutes.
10 minutes late.
hour late.
I get used to it. All right. Okay. Anyway, go ahead, gentlemen. What?
Thank you, Your Honor. My client said he would need 7 days to deposit that money.
He hasn't made a payment in 8 months, Your Honor.
Pardon?
He hasn't made a payment in 8 months. Just getting that on the record.
Okay. So that we're clear on where my numbers are coming from. That's basically 3 months.
That's 3 months.
Yeah. So July, August, and if it's adjourned out, I'd be adjourning it out into September. Right. So,
This courtroom hearing started as a dispute over property ownership, but quickly turned into a much bigger fight over a land contract, a default judgment, and whether the defendant should get another chance to save his property. The case involved Showcase Investments and a defendant who was trying to redeem the property after a judgment had already been entered. But there was a major problem. The defense argued that Showcase Investments did not actually own the property when the legal proceedings were initiated. According to the defense, the recorded deed showed that 2 individuals, not Showcase, were the owners of the property. And that created a serious question for JudgeSimpson. If Showcase didn't own the property, how could Showcase bring the action in the first place? The defense attorney argued that the title problem became obvious when the defendant tried to obtain financing to redeem the property. The lender reportedly refused to proceed